Assalamualaikum and a very good day to Encik Muhammad Nazir. So we are from Group 35. We would like to present our group project regarding to smart legal contract. So these are all my group members. Our group members consist of Siti Nur Sahida, Farhana Shazwani, me myself Nurul Shafika and also Nur Nasira. So I will proceed to the introduction. Based on our topic, which is about the smart legal contract, it correlates with the distributed ledger system. The distributed ledger system is introduced as a new type of technology emerged, allowing the development of specific applications, including the smart contract, which is a new type of the agreement. After using the PDF documents with digital signatures, which is also known as e-contracts, smart contracts will be the next stage in the process of a modern technology. Thus, smart contracts contribute a lot of benefit towards businesses as it achieves high efficiency, cost savings, and also manage to carry out automatically without human involvement. Definition of smart legal contract is a legally binding contract in which some or all of the contractual obligations are defined or performed automatically by a computer program. So next, in smart contract, the terms of a legal document are instantaneously encoded with lines of code and stored in a distributed in blockchain network.
Next, I will continue the presentation with the next part, which is the development on platform of smart contract. Smart contracts have recently been developed on platform based on blockchain, and with blockchain-based platform, developer can create smart contract application using simple interface. There are 5 most popular smart contract platforms, which are Ethereum, Hyperledger Fabric, Corda, Stellar, and Rootstock. Ethereum is a distributed network that is used to run smart contract. Ethereum compiles, runs, and loads software code for smart contract written in the Solidity, Serpent, and Metal language into the Ethereum virtual machine. Second one is Hyperledger Fabric. Hyperledger Fabric is now a platform for collaborative blockchain and smart contract. Hyperledger uses Docker container for smart connection, which is container as opposed to virtual machine. Virtual machine support smart contract implementation with lower latency while lacking isolation. Then Hyperledger embraces standard high-level programming language such as Java and Go. The third one is Corda. Corda is specialist in digital monetary application, and it uses a ledger to support the preservation and sharing of historical record. Corda supports Java and Kotlin programming language, which run on top of the Java virtual machine. Next is Stellar. Stellar is a developer forum for digital currency use cases. Stellar uses application architecture as an account-based platform, then create its own consensus protocol, namely the Stellar Consensus Protocol. Last one is Rootstock or RSK. RSK is based on Bitcoin and allows for faster transaction processing. RSK also creates its own virtual computer to manage smart contract and has been proposed primarily to support currency application. In addition, RSK has an advantage over other systems that are not based on blockchain because it runs on top of Bitcoin.
For the law and regulations, smart contract must adhere to Malaysian law of the Contract Act 1950. According to Section 10(1) Contract Act 1950, states that all agreements are contract if they are made by the free consent of parties competent to contract for lawful consideration and with lawful object, and are not hereby expressly declared void. Section 2A Contract Act 1950 offer when one person signifies to another his willingness to do or to abstain from doing anything with a view to obtaining the assent of that other to the act or abstinence, he is said to make a proposal. Section 2B Contract Act 1950 acceptance is a final and unqualified assent to all the terms of the offer. Section 2D Contracts Act 1950 when at desire of the promiser, the promisee or any other person has done or abstained from doing, or does or abstains from doing, or promises to do or to abstain from doing something, such act or abstinence or promise is called a consideration for the promise. Section 5(1) Contracts Act 1950 revocation can be made at any time before communication of acceptance is complete. Malaysian government has drafted a legal framework where the laws are made to protect the stakeholders and the customers. Therefore, the viability of law consists of banking and financial law. The law consists of, first, the Financial Services Act 2013, second, Islamic Financial Services Act 2013, third, Development Financial Institution Act 2002, fourth, Money Services Business Act 2011, and fifth, Financial Technology Regulatory Sandbox Framework. Security and criminal law. The law are, first, Anti-Money Laundering, Anti-Terrorism Financing and Proceeds of Unlawful Activities Act 2001. Second, Malaysian Penal Code. Third, all the guidelines under the authority of Cybersecurity Malaysia. Fourth, Computer Crimes Act 1997. And fifth, Prevention of Corruption Act 1961. Customers Protection Law. The laws are, first, Consumer Protection Act 1999, second, Personal Data Protection Act 2010, third, Consumer Protection Electronic Trade Transactions Regulation 2012. Digital and Multimedia Laws. The laws are, first, Electronic Commerce Act 2006, second, Electronic Government Activities Act 2017, third, Digital Signature Act 1997, fourth, Digital Signature Amendment Act 2001, fifth, Communication and Multimedia Act 1998, sixth, Copyright Act 1987, seventh, Trademark Act 1976, and eighth, Patents Act 1983. Business and Competition Laws. The laws are, first, Companies Act 2016, second, Partnership Act 1961, third, Limited Liability Partnership Act 2012, fourth, Contract Law 1950, and fifth, Competition Act 2010. Taxation and Revenues Law. The law are, first, Income Tax Act 1967, second, Guidelines on Taxation of Electronic Commerce, third, Goods and Services Act 2014, fourth, Digital Tax. Dispute Resolution Regime. The laws are, first, Mediation Act 2012, second, Arbitration Act 2005, amended by Arbitration Amendment Act 2011, and third, the Rules of Court 2012.
Assalamualaikum, my name is Siti Nur Sahida. In this part, I will tell more about the challenges and the implication on legal smart contract. Basically, we have 4 challenge and implication. Firstly is high requirement for smart contract code security. Since these smart contracts are widely used and this smart contract frequently handle and manage risky digital, people tend to be more concerned on the security rather than security of traditional software. It is because the dealing with money flows through code and surely when a higher scale actually control the code security. Second is hard to guarantee good security. As we all know, the example of smart contract is Ethereum. Ethereum is always publicly open to everyone and anybody may try to hack the code, create an attack and execute it. This smart contract is dealing with money that many attackers are eager to exploit any flaw in order to obtain the asset. As a result, smart contract developers must protect their code from wide range. Next is flaws in compiler. The smart contract compiler has a large number of security flaws. Furthermore, because the compiler is always changing, additional problems may be discovered in the future that the development unaware of. Due to this compiler is always changing and also does not have backward compatibility. The user must either update existing contracts to the new language version to ignore screen full of warning while utilizing this development. Lastly is current debugging in smart contract. Mostly use of the smart contract is complain they are having difficulty to debug smart contract code and debug smart contract application compared to the other software development. The current debugs such as Remix, which can only provide better codes that requires high skill of developers to develop this debugging system of this smart contract. That's all for me. Thank you.
Next, for conclusion section, to summarize this, the smart contract is still in its early stages and has several flaws. But even now, we can see that this type of contract is ideal for repeating transactions that are created using a template that has been significantly modified. Furthermore, when the contracting parties are completely in agreement with one and another, the smart contract is the ideal answer and the contractual conditions are carried out according to the plan. As a result, Smart contracts are projected to disrupt a wide range of traditional industries, including finance, healthcare, energy, and so on. There are some basic ideas and suggestions for how policymakers may approach this adaptation in the short to medium term. Firstly, select the appropriate regulatory measures for the problem at hand. Regulators can select from three fundamental ways to regulating emerging technology like blockchain, each with its own set of benefits and drawbacks. Next, transmit legal views. We believe it is desirable for authorities to make an extra effort to convey blockchain to the wider population when it is included in a law or when a binding or highly definite interpretation of the law with regard to blockchain is obtained. Finally, assist policymakers in gaining a better knowledge of the technology. To do it properly, the relevant authorities and the entire ecosystem will need to grasp this new technology and what can and cannot be accomplished with it. I think that is all from our group. We would like to end our presentation with thank you.